Brought to you by GTA, your island, your network.
If Bill 50 passes, teens who have consensual sex and are less than 4 years apart in age could be slapped on the wrists with a misdemeanor instead of the current charge of a first-degree felony. Speaker Tina Muñoz Barnes puts her personal spin on the issue.
I'd be fooling this community if I didn't say on the opposite approach that why is my grandchild or why is my son going to be punished for having a relationship of a girl that's 2 years younger, but because he turned 18 and she's just moving up, that this relationship, because it's broken up, my grandson's going to be the one that's going to get it for criminal sexual conduct.
However, Dr. Ron McNinch voiced opposition.
I'm concerned that a law like this might send the wrong message. We scratch our heads and wonder, why are we the number 2 criminal sexual assault jurisdiction in the United States? We scratch our heads and wonder, why in the world do we have one of the highest teen pregnancy rates in the United States? And then we end up looking at things and saying, well, on the other hand, it's open season. Guam should not be open season. I think that a 14-year-old cannot give consent.
Attorney General Levin Camacho clarifies the law keeps the age of consent at 16, but says it's a headache to deal with cases when sex is, quote, willing between teens close in age, including 14 and 15-year-olds. But the law also reduces the penalty for consensual sex between 19-year-olds and someone aged 15.
We feel that it would be not just to treat and charge these types of offenders the same way that we are charging adults who forcibly rape other victims.
I just wanted, before I leave, to say under our current statute, you will get less jail time if you negligently or recklessly kill a 14 or 15-year-old than you would to have willing sex between a 17 and a 15-year-old. So I understand this body will set the penalty.
If you prosecute it that way, Mr. Camacho.
Senator Terlaje questioned the AG on the necessity of the law and also said his office already has discretion in how they choose to charge or not charge teens who have consensual sex. Though unable to clarify how many teens are affected by this stiff penalty, Camacho says criminalizing teen sex does not allow his office the choice to offer therapy.
So doesn't the law right now allow the prosecutor to make a motion to the court that it can transfer these cases to family court when that's more just in their mind? When they want these people to avail of the services.
That would require the formal charging. And what Attorney Hinkle Sanchez would testify about is that the formal process of charging a juvenile offender, bringing them to court, increases the likelihood they will commit another offense.
Terlaje also raised concern with the timing of the bill.
It's very hard for me to get my head around the Attorney General's office coming out in a time when we are facing this many sexual crimes and saying that we are going to send this message that 14-year-olds cannot consent. They cannot consent to sex. Their capacity is just not there. So we want to protect them from that, but it's going to be okay if they do it willingly with a 17-year-old. I just feel like we're sending these mixed messages in a time when we all need to get together and send a uniform message.
Meantime, senators also heard testimony for 2 other bills, one that will change the mandatory minimum sentence to 10 years without the possibility of parole for repeat sex offenders. Reporting for Guam News Network, I'm Carmen Victoria Terlaje.
Brought to you by GTA, your island, your network.